Welcome, everyone, to the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
Today, we're embarking on a really fascinating journey into constitutional law. This is episode 18, and our focus is narrowing down to the often overlooked Third Amendment.
That's right. And yes, for those curious, we are indeed bots. We're brought to life by the magic of AI and, importantly, Angela's comprehensive constitutional law notes.
Our purpose here is really to distill those materials for you, offer a clear, engaging, and sometimes, surprising look at these legal concepts, custom-tailored to help you become, truly well-informed.
Think of us as your guides, maybe. Here to light up the important nuggets of knowledge from Angela's sources, keeping it approachable and, dare I say, maybe even a little fun.
Exactly.
But before we really get into the weeds on the Third Amendment itself, there's something vital we need to address. It's right there in Angela's notes, and you really won't want to miss this if the bar exam is your main goal right now.
Okay, what is it?
The Third Amendment is not tested on the bar exam. Let me say that again, just to be absolutely clear. The Third Amendment is not typically a subject you'll encounter on the bar exam.
Wow, okay. That's pretty definitive.
It is. So if you're listening to this podcast episode only to study for your bar exam, this particular discussion is, it's really just for your own education, your own intellectual curiosity.
So nothing we talk about today will actually be on the test.
Correct. Nothing today will appear on that exam. If you're laser focused on just the core bar topics, you might genuinely consider skipping this one. You could jump right ahead to our next discussion on the Fourth Amendment.
Right.
But if you have that genuine curiosity, if you enjoy exploring the less traveled paths of our Constitution, then this episode really promises a unique look. It's an amendment that stands out because of its history and its, almost untouched status today.
It sounds like even the quiet parts have a story.
They absolutely do. And this one has a crucial story and an enduring impact, even in its silence.
Okay. And speaking of the person making this all possible, we really owe a huge thank you to Angela. She is absolutely the brains behind this entire podcast series. Her detailed constitutional law notes are our blueprint.
They really are essential.
And incidentally, for those interested in her journey, you might want to check out an interview with her. It's on the website llmguide.com this month.
Oh, yeah. What's the article?
It's featured in an article called 3 Tips for Passing the Bar Exam from George Mason, University of Miami grads.
Ah, good resource.
Definitely. And Angela doesn't just help students. She also works as a freelance remote law clerk. So if you're an attorney out there, you need help with, say, LexisNexis research, writing appeals, motions, complaints, that kind of thing, or even help setting up your office with AI tools, she's available. Her email for that is hello@legalwriterandlawclerk.com.
Got it. hello@legalwriterandlawclerk.com.
Right. And of course, if you just have questions or feedback about this podcast, you can email Angela directly about that too. That address is podcast@studyforthebarinyourcar.com.
Okay. Her contributions really are invaluable.
Couldn't do it without them.
All right, then let's unpack this amendment. Let's start with the exact wording straight from Angela's outlines. The Third Amendment states,
Okay.
no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
It's remarkably short, isn't it?
It is. Very concise. And this seemingly simple rule against soldiers occupying private homes, it immediately brings up our main question for this podcast. Do we really need the Third Amendment today, in the 21st century?
Yeah, that's the big question.
We'll dig into its history, why it was so necessary then, why it's so rarely used now, and we'll even grapple with how it might hypothetically be tested, just as a thought experiment, pushing the boundaries a bit.
Okay. So to really answer that question, do we still need it?
Yeah.
We have to go back, way back to its origins, to the specific historical situation that made this amendment seem so critical when the Constitution and Bill of Rights were written.
Right. Angela's notes really paint a vivid picture here. It's crystal clear that having troops living among civilians wasn't just some minor annoyance. It was absolutely top of mind for the framers.
What was going on back then?
Well, picture the mid-18th century, specifically the French and Indian War, 1754 to 1763. During that time, the British Army routinely just commandeered private homes, used them for their soldiers across the colonies.
Commandeered, like just took them.
Pretty much. It wasn't about asking nicely. And Angela's materials point out something pretty grim. Many of these soldiers weren't exactly disciplined professionals. A significant number were literally sent straight from jails to the front lines.
Jails? Wow.
Yeah. Can you imagine the fear and disruption? These individuals were often unruly, disruptive, sometimes even cruel to the families whose homes they were forced upon. They weren't guests, they were uninvited occupiers, a constant, oppressive symbol of British military power.
I can see how that would create tension, massive tension.
Exactly. It simmered throughout the colonies, and this forced quartering, along with other grievances, was actually a major spark that helped ignite the American Revolution. The memory of these abuses, soldiers forcing their way in, demanding food and lodging, acting unchecked, it was fresh, it was raw, deeply resented.
So when it came time for the Bill of Rights,
Precisely. After the revolution, after the Constitution was ratified, making sure this specific grievance could never happen again was a huge deal for many states. Angela's notes show that no fewer than 5 state ratifying conventions specifically recommended a prohibition on quartering be included. It wasn't an afterthought. It was a demand born from really harsh experience.
okay, did they all propose the same thing?
Not exactly. They were unified in wanting a prohibition, but the proposals varied a bit in scope, which shows how carefully they were thinking about it. Angela's materials detail 2 main forms.
Like what?
Well, states like Maryland and New Hampshire, for example, their proposals focus strictly on prohibiting involuntary quartering during peacetime. Their main concern was stopping the kind of abuse they'd just lived through, where troops were housed among them, even when there wasn't an active war.
But what about wartime?
Interestingly, their proposals were silent on wartime. Maybe they assumed extraordinary measures would be needed then, or maybe they just didn't explicitly address it.
Hmm. Okay, so what was the other approach?
Virginia, New York, and North Carolina took a broader, you might say more forward-thinking approach. Their proposals had the same tough peacetime restrictions. Homeowner consent was always required outside of war.
Right.
But, crucially, they also said that wartime quartering had to be subject to limits prescribed by law.
Prescribed by law. What does that mean exactly?
It means that even in a declared war, the government couldn't just quarter troops anywhere, anytime. There had to be a formal legal framework, a law passed by Congress, governing how it could be done. It ensured some level of order and accountability, even in conflict.
That sounds much more comprehensive.
It was. And the second version, the one that wisely anticipated future situations, became the basis for what James Madison introduced in the House. His proposal, building on these state ideas, led directly to the Third Amendment we have today. It really shows the framers responding directly to those specific revolutionary grievances.
Okay, so undeniably, it had huge historical importance. A direct answer to oppression.
Absolutely. But here's where it gets really interesting and what makes this amendment so different from, say, the First or Fourth.
Also,
Unlike those amendments, which are constantly being litigated, interpreted, debated in court, Angela's law school notes stress that the Third Amendment is among the least cited by courts, ever.
least cited.
By far. In fact, it has never, ever been the primary basis for a Supreme Court decision.
Never, in over 200 years.
Never. Think about the volumes written about other amendments. The Third Amendment, almost entirely untouched by judicial precedent. It's a real legal anomaly.
That is stark. Which brings us back to the question, do we need it? Why is it so quiet?
Well, the most straightforward reason, tied to modern life, is pretty simple. The practical need for quartering soldiers in private homes just doesn't exist anymore, really.
Because of military bases.
Exactly. Unlike the 18th century, today's military personnel are housed in extensive, purpose-built bases, barracks, designated housing, logistics. The conditions that forced quartering back then are gone.
Makes sense.
But there's another perspective, one we found in Angela's materials, sort of a hot take from a public forum. It suggested that its absence from court isn't a sign of irrelevance, but the opposite.
How does that work?
The idea is that it's hard to find Third Amendment violations precisely because, quote, the amendment is working in its intents and purposes. The argument is that the constitutional ban itself has been so effective at preventing those historical abuses that there's just no need for lawsuits.
So it's like a silent guardian. Its success is measured by its silence.
That's the theory. A powerful preventative barrier. It shapes our expectations about home privacy and the military's place in society. You could even argue it's a cornerstone for later privacy protections, like in the Fourth Amendment, setting an early standard for individual autonomy against state power. Its quietness, in this view, is actually its strength.
That's a really insightful way to think about it. But what about more speculative ideas, modern applications?
Yeah, this is where it gets theoretical, and it's important to stress there's no actual judicial precedent for this. But Angela's outlines mention another interesting take, reportedly from an ABA journal.
Okay.
It pondered whether the Third Amendment could be used to challenge the militarization of police.
Militarization of police. How would that connect?
Well, the argument, purely theoretical, is about blurring lines. Could aggressive military-style police operations, especially if they involve a prolonged presence, or, say, occupation of a private home during a standoff or extended search, could that start to look like quartering? Or could heavily armed police units sometimes act like soldiers in a modern sense?
I see the potential parallel, using military gear tactics.
Right. A proponent might argue the spirit of the amendment is about preventing oppressive state power from taking over someone's home, regardless of whether the uniforms say army or police.
But what's a counter-argument?
The counter is strong. It emphasizes the plain text and history. Soldier meant military personnel, specifically the kind causing trouble back then, not civilian police, no matter how equipped. And quartered implies lodging, staying, not just a temporary tactical presence, even if it's prolonged.
And the framers were focused on the military, not local police.
Exactly. Plus, the Fourth Amendment already provides the main protection against unreasonable searches and seizures by police. Stretching the Third Amendment could dilute the specific protections of both. That's why this idea remains. Speculative courts tend to stick to historical context and plain meaning, especially when another amendment seems more directly applicable.
Which circles back to why it's not on the bar exam.
Precisely. Bar questions need litigated areas, established principles, case law to analyze. Angela's materials make this clear. The Third Amendment just doesn't have that body of law.
Okay. Now, let's talk about this unique challenge we were given. Creating bar-style multiple-choice questions and an essay question about the Third Amendment.
Right, the hypothetical testing.
As we've said, Angela's notes are emphatic, not tested. So this is inherently tricky, right? Bar questions need established law, common fact patterns from cases,
Yeah.
none of which exist here.
It's a completely different situation from the heavily tested areas in Angela's outlines. Think
Yeah.
about the Commerce Clause.
Oh, yeah. Channels, instrumentalities, substantial effect.
Exactly. Commercial versus non-commercial activity, the aggregation doctrine. There's so much case law, so many specific tests.
Or due process and equal protection. The state action requirement, the standards of review.
Rational basis, intermediate scrutiny, strict scrutiny. Angela's notes dive deep into those, explaining exactly when each applies based on the right or classification. Fundamental rights, suspect classes, triggers strict scrutiny, compelling interest, narrow tailoring, tons of precedent.
Federalism, too. Supremacy Clause, preemption, dormant Commerce Clause, the 11th Amendment.
All loaded with specific rules, exceptions, landmark cases, McCullough v. Maryland for necessary and proper, South Dakota v. Dole for spending power conditions, even United States v. Comstock adding new wrinkles to necessary and proper. They all have clear hooks for questions.
But the Third Amendment, it lacks all that.
Completely. No established tests, no nuanced distinctions from courts, no specific precedents to apply, just the text and the history.
Okay, so since there are no actual bar questions, let's explore what hypotheticals we would need to create if it were tested, using the structure of other con law questions from Angela's notes. It helps us understand the amendment's edges, even if they're untested.
Let's get creative. First, hypothetical multiple choice scenario, focusing on peace versus war.
Okay.
Hypothetical scenario 1, a state governor faces a massive hurricane. Infrastructure is crippled, there's widespread looting, civil order has broken down. The governor issues an executive order allowing National Guard troops to temporarily quarter in private homes without owner consent, citing the extreme emergency.
All right, lots to unpack there.
Definitely. The legal nuance. First is a natural disaster, even with civil unrest, time of war under the Third Amendment. Big definitional question, no precedent. Second, are state National Guard members soldiers in the federal amendment's context, especially when doing basically law enforcement? Third, can a state executive order be a manner prescribed by law for wartime quartering under a federal amendment?
So what would the multiple choice options look like?
They'd probe those ambiguities, like A, constitutional because the disaster equals time of war and the order prescribes the manner. Tests broad view of war and executive power. B, unconstitutional because National Guard aren't soldiers under the Third Amendment here. Focuses on definition of soldier. C, unconstitutional because a disaster isn't time of war, so it's peacetime and consent is required. Strict view of time of war, likely the strongest textual argument. D, constitutional, as the governor's emergency order is a valid manner prescribed by law. tests state executive power as law, assuming it was wartime.
Okay, C seems most likely based on the text.
Agreed. Strict interpretation points that way. Now, second hypothetical, focusing on consent of the owner and the scope of any house.
Oh dear.
Hypothetical scenario 2. A peaceful protest escalates into riots. Federal marshals are deployed. Due to urgency, a federal agency directs them to occupy empty rooms in a privately owned, unoccupied hotel near the trouble spot. No owner consent sought, citing public safety urgency.
Okay, nuances.
First, are U.S. Marshals soldiers? They're federal law enforcement, armed, uniformed, but military. Probably not in the original sense. Second, is an empty hotel any house? Does house mean only a residence or any private building? Third, does the emergency override the need for consent in peacetime, especially if the owner isn't available? Options, maybe. A, unconstitutional because marshals aren't soldiers, so amendment doesn't apply, argues threshold not met. B, unconstitutional because any house means occupied residences only, not empty hotels, tests scope of house. C, constitutional due to emergency and marshals not being soldiers, combines justifications. D, unconstitutional because government can't occupy private property without consent in peacetime, regardless of occupancy or who the personnel are. Focuses on core property right consent, likely the strongest argument against, even if 3A doesn't strictly apply, maybe 4A or 5A takings.
Tricky. The definition of soldier seems key there.
It often is. Okay, third scenario. Manner prescribed by law, non-traditional war, and any house scope again. Hypothetical scenario 3. During an ongoing undeclared war on terror, defined by the executive as time of war, Congress passes a statute. It allows the president to quarter active duty military in commercial property, stores, offices, not homes. Statute requires fair compensation, but not consent. A small business owner challenges quartering in their store.
Nuances.
First, does any house include commercial property? Historically, focus was on homes. Second, what defines time of war beyond formal declaration? Does war on terror count? Third, is a statute specifying compensation but not consent a valid manner prescribed by law? The amendment allows law instead of consent in wartime, but does manner imply more?
Options for this one.
Could be. A, constitutional. Congress prescribed manner. War on terror counts as time of war. Broad interpretation. B, unconstitutional. Any house means residential only. Strict textual historical scope. C, unconstitutional. Compensation doesn't replace consent even in wartime. Argues spirit of consent lingers, though textually weak for wartime. D, constitutional. President's declaration plus congressional statute if fails valid basis. Combines branches' actions.
The any house definition seems critical again. If it's just homes, the rest doesn't matter.
Exactly. Okay, fourth one. Direct versus indirect quartering and state authority.
Right.
Hypothetical scenario 4. Peacetime. A local city passes an ordinance. Mandates owners of homes with 3+ spare bedrooms make one available for visiting National Guard during annual training. Offers small stipend, $50 a day. Explicitly states owner consent not required. It's a civic duty.
Oh, trying to get around it.
Yeah.
Nuances.
First, is this direct quartering even with a stipend? Is $50 forced consent? The text demands actual consent. Second, are National Guard in peacetime training soldiers under the federal amendment? Third, and crucially, can a local ordinance be a manner prescribed by law under a federal amendment? Or does the 14th Amendment applying the third to states mean states are bound by the federal standard, consent needed in peacetime?
Options.
Things like A, constitutional. Payment is consent. Guard performing civic duty. Stretches consent. B, unconstitutional. Direct quartering of soldiers in peacetime without consent. Strict textual reading. C, constitutional. Local ordinances manner. Guard aren't federal soldiers. Tests local power soldier definition. C, constitutional. D, unconstitutional because 3A only applies to feds. Incorrect due to incorporation.
D seems clearly the strongest. Peacetime, no consent.
Agreed. The lack of consent in peacetime is the killer argument. Final one, let's bring in torts.
Okay, number 5.
Hypothetical scenario 5. Declared war. Federal statute allows quartering as prescribed by law. Compensation access rules. A soldier, lawfully quartered, negligently starts a kitchen fire, causing major damage. Homeowner sues for damages, arguing tort, negligence, and a Third Amendment violation, infringed quiet enjoyment.
So, does the Third Amendment cover soldier conduct?
That's the core nuance. Is the amendment just about the act of quartering, or does it extend to the behavior of lawfully quartered soldiers? How does it interact with basic tort law?
Possible options.
Might include A, 3A violated. Negligence infringed quiet enjoyment during quartering. Expands 3A scope. B, 3A not violated. Amendment only bars unlawful quartering, not later torts. Strict scope. B, 3A not violated. C, valid tort claim exists, but no valid 3A claim separates the legal issues. B, 3A not violated. D, both tort and 3A claims are valid, tries to merge them.
C seems right. The Third Amendment stops the government putting soldiers there improperly. Tort law deals with the fire damage itself.
That's the most likely interpretation. The amendment regulates the quartering, not the consequences of lawful quartering. Okay, so those MCQs highlight the ambiguities. Angela's materials stress strategies like narrowing down options, spotting key facts. But here, the key facts are the amendment's text and history because there's no case law roadmap.
You're forced back to first principles.
Exactly. Now, let's try the essay. A truly rare beast, a Third Amendment essay question. How would we use IRFOG issue, rule, application, conclusion as Angela's notes teach?
Okay, let's build a complex one. 3 parts, really pushing the boundaries.
Just good. How about this? Part 1. Year 2040. Massive cyber attack cripples critical infrastructure. President declares national security emergency, not formal war. Without Congress, President issues executive order. Military intelligence personnel must quarter in homes of ISP execs and key engineers to secure networks directly. Consent not obtained due to urgency. Discuss 3A constitutionality.
Okay, that's modern. Part 2.
Part 2. Assume Part 1 action is ruled unconstitutional. Congress quickly passes a law retroactively authorizing such quartering in times of national cyber emergency. Law defines military intel as soldiers for this purpose. Specifies compensation procedures but omits consent requirement as unfeasible. Does this new law fix the 3A issue?
And Part 3.
Part 3. A state passes its own law. Peacetime requires owners of large homes, 4,000 plus SKU-EFT, to lodge National Guard recruits during local training weekends. Argues community relations, cost savings, provides nominal payment, $25 a night, no individual consent needed. Analyze this state law under the 3A.
Wow, okay, that covers a lot. Let's IRES it. First, issue spotting.
Right, Part 1 issues, soldier, military intel, time of war, national security emergency versus formal war, consent of the owner, clearly absent, and presidential power versus prescribed by law, executive order sufficient.
Right.
Part 2 issues. Congressional power, defines soldier, time of war, retroactivity, manner prescribed by law, compensation enough, continued absence of consent. Part 3 issues. Soldier, guard recruits, time of peace, explicit, consent of the owner, clearly absent despite payment, and can a state law prescribe quartering under the federal amendment incorporation?
Okay, issue spotted. Next, rule statement.
Straightforward text. State the Third Amendment verbatim. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
But add the crucial caveat.
Absolutely, add. Crucially, this amendment has virtually no judicial interpretation, so analysis relies heavily on text and historical intent, unlike other heavily litigated constitutional provisions. That context is key for a bar essay.
Perfect. Now, the big part, application and analysis. Let's break down Part 1.
Okay, Part 1. President's executive order. Soldier. Are military intel personnel soldiers? Argue both ways. Historically, framers meant unruly combat troops. Modern function is different. Strict originalist view says maybe not soldiers, so 3A doesn't apply. Broader living constitution view says uniformed military acting against private property fits the spirit. Lack of judicial definition leaves it open.
Right.
Time of war is a national security emergency, a time of war, big stretch. Framers meant declared war, actual armed conflict, cyber attack, however severe, probably isn't it. So likely falls under time of peace.
Which means?
Consent. Consent is absolutely required. Since it wasn't obtained, if it's peacetime, it's a clear 3A violation.
But what if you argue it is wartime?
Prescribed by law. Even then, is a presidential executive order alone a manner prescribed by law? Very doubtful. Think Youngstown steel seizure case. President's power is lowest when acting against Congress's likely will or in areas requiring legislation, forcing citizens from homes. Almost certainly needs a specific law from Congress, not just an executive order, especially given the 3A's history of checking executive power.
Conclusion for Part 1.
Likely unconstitutional. Either violates consent requirement in peacetime or fails the prescribed by law standard if you somehow argue wartime.
Okay. Analysis for Part 2. Congress's retroactive law.
Right. Congressional power. Can Congress just define soldier in time of war this way? Congress has broad powers, necessary and proper for defense, but limits exist. 10th Amendment, judicial review. Can Congress redefine terms to bypass a right? Maybe not. Court might say Congress overstepped its interpretive bounds, especially defining a modern emergency as war. Comstock shows scrutiny here.
What about the manner prescribed by law?
Manner prescribed by law. The law does prescribe a manner, compensation authorization. If Congress can validly define the terms, soldier, time of war, then this law likely does satisfy the manner requirement for wartime, because consent isn't textually required then if there's a law. Compensation is part of the manner.
And the retroactivity?
Retroactive law. Probably not a major issue. Ex post facto usually applies to criminal laws. This is more about governmental power, civil rights, less likely to invalidate it on that ground alone.
Conclusion for part 2.
It's a stronger basis than the executive order if the courts accept Congress's broad definitions of soldier and time of war. If courts find Congress went too far in redefining terms, the law fails. If they defer to Congress's defense powers, it likely makes the wartime quartering constitutional under the 3A, very dependent on that definitional power.
Okay. Analysis for part 3. The state law in peacetime.
This one seems more clear-cut. Soldier, National Guard. Are recruits soldiers? Probably. They're military personnel under military command, even if just training locally. Strong argument they fit. And it's definitely peacetime.
Time of peace. Explicitly stated. This is key.
Which means?
Consent. The without the consent of the owner clause is absolute. The law explicitly denies consent, substituting payment. That's a direct violation. Payment doesn't equal consent in peacetime under the 3A. Period.
But it's a state law. Does the federal amendment apply?
State law incorporation, yes. The 14th Amendment's Due Process Clause incorporates the Third Amendment against the states. Angela's notes on incorporation cover this. States are bound by the same rules here. A state can't compel what the federal Constitution forbids.
Conclusion for part 3.
Highly likely unconstitutional. Direct violation of the peacetime consent requirement, which fully applies to the states. Payment and civic duty arguments don't override the explicit text.
Okay. So, finally, the conclusion for the whole essay. You'd wrap it up by strongly reiterating the massive lack of judicial guidance. Emphasize that all these analyses are speculative, based on text and history, not precedent. That's the defining feature of the Third Amendment. You're applying core principles without the usual case law map, making it uniquely challenging but insightful.
It certainly feels like we've journeyed through a very quiet but profound part of the Constitution. From those original grievances about British soldiers,
Right, commandeering home.
to its almost silent status today. It is a fascinating paradox, rarely in court, but maybe powerfully effective precisely because of that silence.
It serves as that silent guardian, maybe, shaping things without needing to shout. And we absolutely must give our sincerest thanks to Angela. Her incredible constitutional law notes are the only reason we can have this kind of deep dive, especially into an area with so little standard legal commentary.
Absolutely. Her research, her outlines,
Yeah.
they make this possible.
And just to be super clear on some essential housekeeping points,
Yes.
Angela is a law student. Just like many of you listening, she's not an attorney yet, hasn't passed the bar, so very important. Neither Angela nor this podcast is giving legal advice. Nothing here should be taken as legal advice.
Got it. No legal advice.
And remember, AI tools like us, we're aids. Powerful aids maybe, but not a substitute for your own hard study for the bar. Think supplement, not shortcut. This podcast should add to your learning, not be the only way you study.
Good point.
Also, AI isn't perfect. We're not always correct. Sometimes we AI hosts might make a mistake. Angela does her best to catch errors in her notes, but hey, even law students make mistakes sometimes. And AI definitely does.
Understandable.
And finally, this podcast, the whole series, it's an academic, non-commercial project for Angela. Strictly educational. It's a passion project, really.
Okay, all important points, and one more from me. If you're listening while driving, please, the most important thing is be safe on the road. Pay attention out there.
Definitely. Don't cause a tort while listening to con law.
Exactly. A vital reminder. So, if you need Angela for professional freelance help, that email again is hello@legalwriterandlawclerk.com.
And for general podcast feedback or questions, it's podcast@studyforthebarinyourcar.com.
Perfect. Now, before we sign off, tradition dictates. A cheesy Third Amendment joke.
Oh boy. Okay, hit me with it.
Why did the homeowner invite the soldier to stay for dinner during peacetime? Completely against the spirit of the amendment.
I don't know. Why?
Because he needed help moving his furniture, and he heard the soldier had extensive experience with quartering.
Okay. Quartering furniture. I see what you did there. That is sufficiently cheesy. Well done.
Thank you.
All right. We're your AI hosts, Claude and Maude, signing off for today.
We'll see you on the next podcast. We'll be moving on to the equally fascinating and much more frequently litigated Fourth Amendment. Thanks so much for listening. Bye.
Bye, everyone.